Good afternoon, everyone. Thank you very much for calling in and attending this webinar. My name is Amy Briggs. I'm a member of Farella's Insurance Recovery Group and also of Farella's Real Estate Industry Group. Before I begin, I want to apologize in advance for two possible disruptions. One is my dogs, who unfortunately are in the room next to me, and the other is my teenagers. So if you hear background noise, that's all it is. I've done my best to keep all four quiet. It's proven virtually impossible. So in addition to my apology, I want to invite the audience to ask questions. If you have a question, please don't hesitate to share it on the chat. I guarantee you, if you're thinking about it, other people who are attending this webinar are thinking about it as well. And as much as, as an attorney, I love to hear the sound of my own voice. Really, the purpose of this webinar is for you, the audience, and to get to the heart of the issues that you're facing today in your business. So I can't encourage you enough to throw a question out, regardless if you think it is uninteresting to the rest of the audience or perhaps stupid. No such thing. Please don't be shy on that front. It will make for a much more successful presentation. Next. Very briefly, what I'm going to be going over with you for the next 40 minutes here is I'm going to be talking about the current litigation environment in light of COVID-19, with a specific focus, of course, on the business interruption COVID-19 litigation that has been brought nationwide and, in fact, worldwide. We're going to be talking about some of the takeaways for policyholders from that existing litigation. Then I'm also going to touch on other insurance that may be applicable depending on your particular situation. And that will lead into a discussion of preventing collateral disputes with your insurance company more generally. Some tips, some kind of tips of the trade there. And then I will conclude by giving you an overview of what is going on legislatively to deal with some of these issues. Next, please. So very briefly, this was taken from a company called Lex Machina, which does data analytics. What you can see is that the number of complaints, new court filings referencing COVID-19 has increased dramatically. This only goes through early May. I think if it were more current, you would see those cases continuing to rise. Next. This breaks the new filings down. This chart breaks the new filings down by type of litigation. I don't think it's particularly surprising to see that in terms of the litigation actually being caused by COVID-19, that contract disputes are at the forefront of that, and insurance disputes are not that far behind, and insurance may even have caught up at this point in time. Next. So on those two categories, the contracts, just for your information, that surge in contract claims is being driven largely by consumer class actions. We're not really going to be talking about that today, but those, the plaintiff's bar has brought those class actions on behalf of consumers who purchased goods or services prior to the shutdown, and then were not able to use them. And as many of you know, oftentimes instead of fully refunding, there were credits given or something else, and it left consumers very unhappy. So that's driven a large number of those lawsuits. And then, of course, impossibility and force majeure type of contract disputes, which Adam and Rick talked about yesterday. Again, we're not going to be talking about that today. And then obviously the insurance, as I mentioned, being largely driven by the business interruption litigation. Next. So I'm going to provide you with a brief overview of kind of what is going on in that business interruption litigation, beginning with who has sued. And what you'll see is that who is suing is playing a big role in the types of litigation that are being brought. So not surprisingly, Many small businesses who were shuttered completely, particularly the in-person services, restaurants, hair salons, gyms, all those types of businesses have sued, in addition to some larger enterprises. It made headlines a couple of weeks ago. Some of you may have seen it. The Houston Rockets filed a lawsuit in Rhode Island over the shutdown. And then a number of colleges and universities have also sued. The form of the litigation that these actions have taken vary. Of course, you have individual policyholder actions, which is not surprising, but because many of these businesses are smaller and really couldn't afford to fund a full-blown litigation against an insurance company, or perhaps their losses were not significant enough to warrant that type of litigation, they really banded together in two different ways. One is what is referred to as multi-district litigation. For those of you who aren't familiar with what we call an MDL, it is akin to a class action proceeding, but not quite the same in terms of the individual actions remain individual, but they are all coordinated before a single federal MDL judge for purposes of discovery and other pretrial proceedings. The difference being in class actions, which have also been brought, in class actions, it is a single action, a single lawsuit. So those are the three different types of actions that are being filed almost daily across the country. Next, Margaret. Before I get into a deeper dive into how those litigations are doing, I wanted to highlight at a high level for you some of the coverage issues that are being fought out in the courts right now. And it is important to begin with what I think is the most important caveat when we're talking about business interruption litigation, one that you've probably already heard before. It is more than just, read your contract, although that is an extremely important aspect to any coverage issue. The higher level takeaway about this business interruption litigation is that the contracts vary widely in terms of the language and the coverage that was afforded and sold. And even small differences in language can make huge differences in the outcome of a particular litigation. So all policyholders should be aware that regardless of what they're hearing on the news about, a lawsuit got dismissed or whatever, it may or may not have anything to do with what is going on in your insurance program. The biggest issue, and the one that I'm sure you've all heard about, is the debate over whether or not these policies require physical damage to property. Policyholders are arguing, they've made a bunch of different arguments. One is that some policies are triggered just by the loss of use of property, regardless of any physical damage to that property. And the secondary follow-on question is whether or not the presence of the virus in and of itself can constitute physical damage, thus satisfying kind of the threshold issue for coverage. And there have been some court rulings addressing that, and we're going to get to those in just a minute. In addition, many of these policies come with civil authority or contingent business interruption coverage, and there's a separate inquiry as to whether or not those specific sections of coverage require physical damage to the property itself. Some policies were written so that even though physical damage was required, it's not even necessarily to the insured's property. So you might have a policy that provides coverage when there's physical damage to a nearby property. And then lastly, of course, there's a raging debate over the virus exclusion and what that means. Next. If any of you, by the way, if any of you have questions about those coverage issues, feel free to either put them in your chat or contact me later. I'd be happy to talk to you about them further. So turning first to what's happened so far in all of this litigation, I'm going to talk first about the individual lawsuits and where they are. And it is important to keep in mind, really important to keep in mind, that this litigation is in very, very early stages. And there are a lot of developments yet to come. Primarily, however, policyholders have been advancing two different types of arguments. One, the first argument is that civil shutdown orders in and of themselves caused damage to insured's property because it caused them to lose the use of their property. So a hair salon, for example, or a restaurant that could not open during certain time frames. The second argument is that the presence of the virus on the property itself has caused physical damage, thus triggering the coverage in some way. And I make this point because what we're going to see is that those two different arguments have played out very differently in courts so far, notwithstanding that it's still early on. To date, 5 courts have rejected the argument that the civil order itself causes physical loss, particularly where none of those policyholders have been able to allege that the virus was actually on the premises. What's interesting about those, about the court's decision in those cases is that 4 out of the 5 decisions were rendered quite early on in the proceedings in what we call a pleadings challenge, meaning that there was no evidence before the court. The only thing before the court was the policy itself and the allegations of the plaintiff, and the court decided that the lawsuit could not proceed any further on the merits because the plaintiffs did not have a claim. The standout, of course, that's being talked about quite a bit came out of a Missouri federal court recently, which flat out rejected the insurance company's early attempt to dismiss the case. And the significant distinguishing factor from my perspective is that this was a policyholder that was able to allege that the virus was on its property. And what the court said, and I've quoted a little bit of it here, is that the presence of COVID-19 is not a benign condition, as some have argued, and that the allegations that the virus itself was a physical substance that attached itself to the insured's physical property and rendered it unsafe and unfit for use was sufficient to allow the lawsuit to proceed. Now, to be clear, this was not a ruling on the merits of either side's claims or defenses. What's going to happen next is that the policyholder in this case is going to be allowed to conduct discovery against the insurer, and the insurer will be conducting discovery against the policyholder, and there will undoubtedly be further motions brought before the court with evidence asking the court to again revisit this issue regarding coverage. Again, as I mentioned, and just as a reminder, although the insurers are touting, what have certainly been some early successes, I would just caution that I think this is far from over. Next, please. Moving on to that other type of proceeding that I had mentioned, the multi-district litigation. Again, these are smaller policyholders who are trying to coordinate all of the proceedings from around the country that are currently pending in federal court before a single judge to make it more efficient to conduct discovery and other pretrial proceedings. So 2 groups of policyholders, you have to ask permission essentially to become an MDL. You can't just decide that you're going to form an MDL. So you go to the MDL panel and ask for permission to do that. There were 2 groups of policyholders that went and asked the panel for permission, saying they thought it should be a multi-district litigation. And just a couple weeks ago, the panel rejected their petitions in part. And I think what they said about the cases is of some interest to policyholders sitting here today. As an initial matter, there was no common defendant, right? Many insurance companies have been sued in this litigation. And so the court concluded that there was little potential for common discovery, which really meant that there wouldn't be the efficiencies gained that you often see in MDLs. The court went on to note that all these proceedings involve different insurance policies with different coverages, again, alluding back to the point I made earlier, which is these contracts are very different. They contain different terms, conditions, exclusions, etc. In addition, they were obviously purchased by different businesses in different states and arguably governed by different state laws. And the panel ultimately concluded that these differences will overwhelm any common factual questions, therefore really undermining the entire premises of the efficiencies to be gained in an MDL. The court, I do want to make a note about this, however, because again, in terms of the audience, you sitting here listening to this today and knowing what your coverage is, the MDL panel did not completely reject those petitions. And that's an important point. What they said was that it might make sense to bring kind of consolidated, coordinated actions against single insurers. And the logic there being, of course, that a single insurer would be more likely to have written coverage on the same form. So you really would be litigating over the same policy language and therefore have common sets of discovery. The panel initially identified 4 potential insurers: Lloyd's, Cincinnati, the Hartford, and Society Insurance, primarily because they alone constituted 35% of the cases that were seeking petition. And then later, they issued an order to show cause to Travelers as to why there should not be a coordinated proceeding against Travelers. I want to take a moment and just address a question that came up about whether a biohazard exclusion is the same as a virus exclusion. And first, thank you for that question. And the answer to that, I think, is probably yes, but I would very much want to see the language of the biohazard exclusion that you're referring to before drawing a more definitive conclusion. But my initial reaction to that question is that most likely it's the same thing. Next, Margaret. Finally, I wanted to touch briefly on class actions. There have been no rulings to date, but we are very likely to see the same types of issues that were before the MDL panel. These class actions, it's important to note, have been brought against single insurers. So I think there are still going to be some hurdles in getting these actions certified as a class. But they've overcome, I think, the most significant hurdle that was faced in the MDL, which is they've only been brought against a single insurer. So no class action has been brought, for example, against 10 different insurers. Next. I would be remiss if I did not mention two, I think, important international developments that could have some impact on what's going on in the United States. In the UK, the regulatory body that oversees insurers, at least in part, is the Financial Conduct Authority, the FCA. What is interesting about what happened in the UK very recently at the end of July is that the Financial Conduct Authority invoked a rarely used statutory provision that allows it to bring its own lawsuits, and it did. And it did so actually with the consent of the insurers who participated, and I've listed some of them out there for you. And the purpose of this proceeding is to determine whether or not there is coverage for business interruption claims in the UK. Obviously, if you look at this list, these are names of US insurers as well. So it is possible that whatever the FCA, the outcome of that particular trial could have implications here in the US. I reached out to a friend practicing in the UK today, and what he told me, he's actually representing one of the insurers, although not one that was involved in the trial. What he said is that a draft decision is expected sometime in the next couple weeks, and that a final decision should be out by the end of September. So keep your eye on that. And then in France, with France's largest insurer, AXA, who some of you may be covered with, was recently ordered by a court to pay a restaurant's claim for being locked down for several months. And after that order came out, AXA then agreed to cover the losses sustained by all of these French cafes during the shutdown that it had insured. So I thought that was pretty interesting. Next. Okay, so if you are a policyholder listening to kind of the disparate results that are occurring around the world and even in the US, what are you thinking about and what should you be thinking about? I'm assuming for purposes of this discussion that you haven't filed a lawsuit yet. Maybe you've submitted a claim, but maybe you haven't. The first thing I would want to know is, am I part of a class action already? Is a plaintiff's attorney trying to bring an action against my insurance company involving the same or very similar language? Because as everybody knows, class actions can have binding implications if you don't opt out. I think I would also want to know whether or not my insurance company was part of the FCA trial. If I'm insured by Zurich, I think I would be very interested to know whether or not over in the UK, Zurich is going to be found responsible for the business interruption insurance, possibly on the same language that it covered me with. I think I would also be thinking about the size of your particular loss is if you have a claim. That said, as I mentioned early on, a lot of these claims are being brought by smaller businesses who have banded together to make it cost effective to pursue litigation, and that might be right for you. These are being prosecuted by contingency fee attorneys, which means little to no cost to the policyholder, and that might be something to seriously consider. Next. We've been focusing on obviously the business interruption insurance, but I wanted to mention other types of insurance that could be at play for you. Builder's risk, obviously, I think I would want to take a look at my policy, particularly if my project were delayed in starting up or delayed in completion. These policies can provide coverage. I would also be thinking about whether or not that was because there was, workers were sick at the project and so it had to be shut down. Those would all be important considerations because builder's risk, like the business interruption, typically requires some type of physical damage. I'd also be thinking about my subcontractor default insurance for ongoing projects and reviewing that. I think with the general economic downturn, it is much harder for businesses to survive, particularly with employees getting sick or maybe concerned about getting sick. In fact, in yesterday's presentation, one of the presenters, and I can't remember if it's Adam or Rick, talked about a project where a subcontractor just walked off because they were unwilling to bring their employees to a job site given the risks associated with COVID-19. And then finally, I would also be thinking about pollution legal liability insurance. If the insurers are going to take the position that the virus is a pollutant, then that arguably triggers coverage under a different set of policies that some of you may carry. I noted that I made a note about a New York hospital system which has filed suit under its pollution legal liability. There is no doubt what they are arguing is that, essentially the cleanup cost associated with the presence of the coronavirus everywhere, particularly in New York, where they operate, led to them incurring huge amounts of loss, and that it is therefore covered under their PLL coverage. And I think that'll be a very interesting lawsuit. Next. Finally, the last three that I wanted to mention are general liability, employment practices liability, and workers' compensation or employment liability coverage. On the general liability front, obviously that is not going to respond to claims by your employees, or employees are typically excluded from coverage, but would come into play where non-employees are making claims. So by way of example, we have cruise ships, right, where the passengers have sued Carnival and multiple other lines where there was an outbreak aboard the ship. Interestingly, I just put a note here. It's not really on point, but I thought it was interesting that here in California, those passengers had brought, I believe, a class action alleging that they were injured, emotional distress, because they were afraid of getting the coronavirus. So these are not passengers who actually got sick, even though there were sick passengers on board. These were passengers who were afraid that they might contract the virus, and therefore spent, 2 or 3 weeks in fear that they were going to catch this illness. And the court dismissed those claims altogether, saying that it's not a claim that could be prosecuted. Of course, nursing homes are facing significant liability as well. Those are from both residents and visitors alike, undoubtedly. I also wanted to note a interesting aspect of general liability that really sets it apart from the business interruption coverage that we've been talking about. And that is that property damage is an essential element of a claim to trigger coverage under a general liability policy. However, property damage is specifically defined in most policies to include the loss of use of property that has not been physically injured. So a much broader definition there should litigation arise out of the shutdown of various projects or properties. Then, of course, employment practices liability insurance for employees who allege that there's discrimination. For example, perhaps they've not felt comfortable returning to work due to underlying health conditions or their age, or retaliation. Adam, thank you. Really good question. He's wondering how insurers are likely to change coverage language as a result of the pandemic. I think a particularly good question, given that I think if you talk to any insurance company representative, they would say, we already excluded coverage. There may not be anything, there's nothing left to change. And that is in part true. Going back to this idea of the virus exclusion, where a question was asked earlier as well, these virus exclusions came about, almost 2 decades ago after some of the other virus-related pandemics, ones that fortunately did not hit our country too hard, but certainly hit the rest of the world. So SARS was the impetus behind the insertion of the virus exclusion in the first place. And that took place a long time ago. So I think that for those insurers that did add virus exclusions to their policies, I think they would say, well, we don't need to change anything. We dealt with this 20 years ago. It's not quite 20, maybe 17 years ago. But I think insurers who issue policies that do not have virus exclusions in them currently, I would expect to see that going forward. And then finally, workers' comp and employers' liability coverage for employees who allege that they contract the virus on the job, or that safety precautions are not being taken, and as a result, they were exposed by other coworkers, et cetera. Those claims are already being filed. They're already out there. McDonald's is a notable one. Amazon is another. Next, Margaret. So what do you do if you're on the fence and not really sure whether or not it's worth it to pursue a claim? What I want to spend a couple minutes talking about is how to make sure you don't lose your rights under these policies before you ever decide whether or not to make a claim. And one of the features about business interruption coverage, along with builder's risk, that's really important for everybody to understand is that these have built-in statute of limitations. They're contractual statute of limitations. And what's really significant about these contractual provisions is that they are typically much, much shorter than your state laws governing statute of limitations. So, for example, most of these policies have a 1-year contractual statute of limitations on them. That means that if you do not file suit against your insurance company within 1 year from the date of loss, your claim is barred, period, forever. Under California law, absent that kind of provision, a policyholder would have 4 years to bring a breach of contract claim before it became time barred. So these can radically shorten the time frame that you as a policyholder have to decide whether or not to bring a lawsuit. Question, Rosa, yes, I'm going to share this. You will absolutely get this presentation. So it's a really important feature of these policies that everybody needs to keep their eye on. Know when your time to file suit runs, and if necessary, get a tolling agreement from your insurance company in writing, extending that contractual statute of limitations so that your claim does not inadvertently become time barred. And as hard as it is to believe, we are 6 months into this pandemic. And the next 6 months are going to go by pretty quickly. So make sure you've got your eye on that ball. Next, please. So if you want to go ahead and preserve a claim, you put your carrier on notice. That's your first step. It doesn't have to be anything fancy. It doesn't have to be detailed. You can use your broker to do it. They're doing hundreds of these every day. They have it down to a science. But what I want to prepare you for is the result of that kind of notice. The carrier will respond by investigating your claim. And what I have seen is that these investigations can be quite detailed in nature. And the reason for that is that at the beginning of the pandemic, and if there are any brokers on the phone or any insureds who actually submitted a claim, I think they can attest to this. What happened is a notice would go in, a very straightforward form, nothing crazy, saying that because of the shutdown that's just occurred, we're submitting a business interruption claim, and the insurers were responding by denying coverage right away. I have a friend who's the CEO of a company, and her claim was denied the afternoon that she submitted it. So insurance companies were not waiting to stake out their position on coverage and were very, very quick to respond. They weren't investigating. They were just saying, no coverage, no way under any circumstances. So what happened, not surprisingly, the California Department of Insurance got involved and ordered insurance companies to I think they ordered them to comply with the law. That's what I think the effect of this is. They basically said, investigate the claim as you're obligated to under California's Fair Claims Practices Act. Okay, so what that meant is that now when insurance companies get claims, they have been sending my clients questionnaires that are about 11 pages long, asking for all sorts of backup information because they don't want to run afoul of the Department of Insurance's order. I understand, but just be prepared for that. Next slide. These policies contain a proof of loss requirement, which asks the policyholder to submit a proof of loss, often within a certain time frame. You don't have an unlimited time to submit a proof of loss. So read your policy, know what your time frame is to submit your proof of loss, get an extension if you need one. These are routinely granted, but don't get tripped up with all these kind of internal timelines that are happening once you set the claims process in motion, because that can end up really coming back to haunt you, even if you have a meritorious claim. Courts around the country enforce these provisions differently, and you just want to make sure that you've dotted your I's and crossed all the T's that are in the policy. Next. I wanted to briefly mention kind of an issue that's near and dear to my heart under claims made policies. And I mentioned a couple of examples of claims made policies, your employment practices liability policy by way of example. And the reason I put this in here, and there may be others, some people have a general liability coverage written on a claim made policy. I hope you don't, but you may. And these policies can be really tricky in terms of notice requirements. And I would say that if there is a single perennial issue in my practice, it is policyholders getting tripped up on notice under claims made policies. So when I say claims made policies, what am I talking about? I'm talking about a policy that is triggered not by when an accident or injury occurred, but instead by when the claim itself is made against the policyholder. So for an example, somebody visiting the insured's premises might be injured in one policy period, but might not file suit until another policy period. It is the time of filing suit that controls the policy period that responds to the loss. So that's what we mean by claims made policy. Claims made policies have what can be very stringent reporting requirements. Sometimes they even require that a claim be reported by the end of the policy period plus a modest extended reporting period. So you want to make sure that you are really paying attention to those if you have claims coming in that could be covered under claims made policies. By the way, the biggest problem that I see is a claim comes in and the insured reads the claim and says, oh, well, there's no coverage for this, or I only need to report this under my general liability policy, not under my employment practices or not under my E&O. And what happens over the lifetime of litigation, you guys have all experienced this, claims and allegations change. And so all of a sudden, a lawsuit that didn't appear to be covered under one type of coverage, suddenly there are allegations and, oh my goodness, I should have put the carrier on notice. So a lot of questions I get from the policyholder is, well, the allegations just came out. They came out 2 years into the litigation. I couldn't have known way back when the litigation was initially filed that I should be reporting under this type of policy. I hope you were all sitting down for the news flash. Insurance companies don't care. The reporting requirement applies to the date the claim is made, even if you don't think it's covered. So don't lose your coverage on this just because you don't report something thinking that there's no way it's ever going to be covered. So what is the claim? What is it exactly that you need to be thinking about and possibly reporting? Another, I think, area of quicksand for policyholders, because claims are generally very broadly defined as demand for monetary or non-monetary relief. Sometimes there's a requirement that a claim be in writing, that demand be in writing in order to trigger coverage, but not always. So that can lead to all sorts of questions of, well, I have a letter here from somebody who claims to, who says that they're injured, or who says that we need to have better COVID-19 protocols. Is that a claim that I need to report? Good question. Check your policy. Is that demand for non-monetary relief? If you get a letter from somebody insisting insisting that you need to change your protocols to avoid injuring other people, perhaps. Okay, I'm running out of time and I do want to make sure everybody has time for questions. So I'm going to go over these pretty quickly, these next couple slides, and of course can revisit anything that I go over too quickly. There's a provision in your policy also called notice of circumstance, which is a way to help you manage your claims reporting. And it can lock in coverage for something that is now just a circumstance that you're worried about might ripen into a claim in a future policy period. I mention this because if any of you on the phone are involved in renewals right now, you might be having a hard time. This is a very difficult market for reasons that I'm sure everybody can imagine. And so sometimes it's helpful to report potential claims under your current policy, and it kind of locks those claims into that policy period, leaving insurers for future policy periods with the knowledge that if something does develop into a claim from that particular reported circumstance, it won't be them. It won't be them responding. It'll be that prior carrier that you put on notice. And then no voluntary payments. This goes beyond claims made policies. Insurance companies generally do not like to pay for attorney's fees and costs or anything where they have not been given notice first. So always, always, always get timely notice out, because it puts the burden then on the insurer to say why it shouldn't be covered as opposed to the other way around. Next, please. Okay, last piece, and I will whip through this. What's going on legislatively? The California Department of Insurance took some early actions, including some rebates, mandatory rebates on premiums. I hope that some of you were able to take advantage of that. Early on, they issued a mandatory data call to insurers to kind of get their head around what the scope of coverage, business interruption coverage was for California policyholders. I've not seen any update on what, if anything, they have done with that data. So kind of a wait and see. Next, please. There are a couple of pieces of pending legislation that everybody should be aware of, because again, I think this goes into the mix of your thinking as to what you should be considering as your next step if you were impacted and shut down by some of these civil orders. The bill that is currently being proposed would create rebuttable presumptions. These are rebuttable evidentiary presumptions. Notably, if in the first one, if the policy does not have a virus exclusion, then the income losses suffered by a business will be rebuttably presumed to be the result of a pandemic, which resulted from physical damage under the policies. Remember, that was the first issue that I told you was a coverage dispute. This creates a rebuttable presumption that satisfies that physical damage requirement. The second one says that unless the policy expressly defines a pollutant to include viruses, that the coronavirus is not a pollutant and therefore not excluded from coverage, and these would be retroactive bills. Now, some of you may be saying, what is a rebuttable presumption? That's complete lawyer talk. Basically, what that means is when you go into court as the policyholder, you have an evidentiary presumption in your favor so that you don't have to prove these presumptions. It shifts the burden to the insurance company to then negate that presumption. So you walk in with a bit of an upper hand. The thing that I like about this bill is many of you may have heard the insurance industry talking about contracts clause challenges if any state legislature tries to make them cover these claims. The primary basis of such a challenge would be the contracts clause in the US Constitution, which says states can't interfere with contracts. I think this does an end run, frankly, around the insurer's contracts clause argument. Anyway, next. Other state legislatures are also considering different types of COVID-19 business interruption litigation. There are some common features, which is that which is that the coverage would be available regardless of the scope of coverage or exclusions in the policy. And it would also be a state-backed reimbursement plan. So the insurers pay and then they get reimbursement from the state. None of these have really gone anywhere yet. Next. There's also some federal legislation. Again, it has a very similar theme: voluntary payment by the insurance industry with some kind of government reimbursement for these business interruption losses. Next. So takeaways: read your policy, consider your legal options, consider any timing restrictions that you might be under, make sure to perfect your rights, and stay informed of developments. I'm going to pause for questions because Margaret is going to turn off the recording, and then hopefully she's going to invite you all to join by video, which I hope you do. Even if you decide not to, please continue with the great questions that are being asked. Thank you.